SJC-13453, Commonwealth versus Lance Hullum.
Attorney Rose, whenever you're ready.
Thank you. Good morning, and may it please the court. My name is Rachel T. Rose, and I represent Lance Hullum. Hullum's motion to dismiss should have been granted as to some of the charges. The single justice's analysis wasn't quite right because the situation has changed now that we're locked into the realities of the first trial. The Commonwealth chose to structure Hullum's prosecution in an unusual way by indicting him for the Shiv attacks via a bunch of subtly differentiated charges that all stem from the common root of assault. Instead of starting with the most serious charge for each attack and asking the jury to work its way down through lesser...
Slow down just a bit.
Instead of starting with the most serious charge for each attack and then asking the jury to work its way down through lesser included offenses until it reached the appropriate level of culpability, they asked the jury instead to take each charge and place it against the evidence to see if it fit. They weren't told anything other than what the elements were and what Hullum was alleged to have done. So they were measuring the same incident, the same quick attack with something sharp, against each statute. That means that when they rejected the only aspect of assault with intent to murder that differentiated it from the other charges, they rejected the only thing making it non-duplicative. So it's not an implied acquittal, it's an actual acquittal on the intent element, followed by merger of the now duplicative charges. The Commonwealth couldn't have originally indicted and tried him for assault and ADDW for the same Shiv attack without it being duplicative, and so they shouldn't be able to do it now just because they started out with something worse. Hullum's entitled to dismissal of the assault charges before his second trial, but even if they ran it again and he was convicted of both assault and ADDW, he'd be entitled to have those lesser charges dismissed afterwards anyway. In order to try him on assault, as well as assault with intent to maim or assault and battery with a deadly weapon, the prosecution would have had to run the trial completely differently. Maybe asking for an instruction tying the assault charges to the victim's claims that Hullum squirted shampoo at their eyes to make them flinch before going for them with a Shiv. But it's too late for that because the indictment was for assault to murder with the Shiv. The jury didn't find Hullum's guilt in his second assault as well as the Shiv attack. What they found was that the Shiv attack wasn't an armed assault with the intent to murder. Respecting the jury's verdict means that those charges have to be dismissed, as well as any of the others for which the jury in his second trial finds him guilty only of the lesser included offense of assault, unless, of course, that's the last charge for that particular victim. And that brings us to the assault to maim mayhem second theory and the ABBW charge. Well, the Commonwealth is right that under the Maury elements test, these two can be distinguished from each other. Under Crocker, for my 16L letter, that's not always the last word on the issue. Again, the difference here is that we're locked into the realities of the first trial, and that limitation is what makes ABDW a lesser included offense of assault to maim under the route taken through the mayhem statute. Mayhem second theory includes an intentional touching because it punishes those who assault someone with a dangerous weapon, thereby causing serious or permanent physical injury. So ABDW is considered to be a lesser included offense of that. That what was charged as assault to maim and not mayhem itself normally would be enough to distinguish the two charges, but not when we've already run the trial before. There's no question whether a touching occurred. So all we're asking a new jury to decide by looking at both statutes is whether the elevated level of intent and intended injuries from the mayhem statute was present. That means assault and battery with a dangerous weapon is a duplicative charge. Had the Commonwealth originally charged it as mayhem, the jury could have worked down through mayhem, assault to maim, and assault and battery with a deadly weapon. It doesn't seem fair that they should be able to circumvent that by charging an assault rather than a completed one when they know you're going to get both. Even if the Maury standard is satisfied in the indictments, once we know exactly what evidence is coming out at trial, it's safe to say that in these circumstances, the two offenses are sufficiently closely related so as to preclude punishment of both. The retrial for Hullum should proceed with the charges against him winnowed down to, for each victim, only the most serious of those for which the jury found his guilt beyond a reasonable doubt. That's ABDW for one victim and assault to maim for the other. Doing this is the Constitution's answer to the Commonwealth's tactic taken here of overcharging him via multiple different paths to capturing the same criminal wrong for each victim. Does anyone have any questions for me? Then I'll rest on my brief. Thank you.
Okay, Attorney Marble.
Good afternoon. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. It is the Commonwealth's position that there has not been a clear error of law, nor has there been an abuse of discretion made by the single justice in denying the motions to dismiss. In other words, in upholding the Superior Court judge's denial of the defendant's motion to dismiss. The reason for that being that double jeopardy is not implicated here. These were multiple indictments of various offenses. Each had elements distinct from the other. So for those reasons, they are not duplicative. In addition, the convictions were vacated. So his longstanding principle that says that where a conviction has been vacated and it wasn't because of insufficient evidence, it wasn't a sufficiency of the evidence issue, it was a procedural issue, as was in this matter. The colloquy given to the defendant who proceeded pro se was deemed by the appeals court to be insufficient. So it was a procedural issue that led to the convictions being vacated. That kind of overturning, vacating of those convictions does not bar the Commonwealth from retrying.
He just can't be sentenced on duplicative.
Correct.
So he can be retried, but he just can't be sentenced.
Correct, but we're, right,
Not
that's
there
not
yet.
where we're at. So the issue here is whether or not the Commonwealth is barred from retrying, which is the Commonwealth's intention as laid out in the brief and as well as noted in the decision by the Superior Court judge as well as the single justice. For all of those reasons, the Commonwealth's position that we are not precluded from going forward and would ask that this court affirm that decision.
Okay.
Are there any questions?
I think we're all
No.
set.
Then the Commonwealth would rest on its brief. Thank you.